Your child's preferences may not come into play in your Texas custody or divorce case at all. In fact, if children are under 12 years old in Texas, a court doesn't even have to consider their wishes or opinions. The thing is, once children turn 12, there's this old, long-standing sort of urban legend that they get to pick which parent they want to live with. But that's not actually how it works. At 12 years old, on motion of a party, a must consider and visit with the children in a divorce or custody case. So at 12 years old, all that has to happen is a judge has to listen to the kiddo and hear them out. And then what happens is they give the weight and credence to what the kid is saying based on the judge's own assessment of this child's maturity and ability to understand the situation. So if you think about it, how much credence would you give the 12-year-old in your life? Like, do they have a hard time managing their business? Are they still pretty immature and young? Maybe not as much credence. If you are having a 12-year-old who completely understands things, super responsible, can stay home by themselves and, stuff like that, maybe you'd give them some more credence. But like under 12 years old, y'all, courts are not going to consider the child's preferences. Now, sort of a backdoor way this can happen, perhaps through the testimony of a therapist. If your kiddo is seeing a therapist, a court might consider what a kid feels based on what a therapist would explain. But like directly, kids don't get to have a say in what a court does with where they're going to be and with which parent for how long. We really go back to the Texas Family Code and then a judge's assessment of what's in the best interest of your child.